Well, I usually wear a coat and tie when I do this, my official professor-type uniform, but it's kind of warm in here, so I shed a few layers. Just to tell you a little bit about myself, I used to be a federal employee, a bureaucrat, one of those sorry Forest Service and BLM guys, but I repented, so I took a vow of poverty and went into consulting, and that's what I've been doing most of the last 20 years or so. I worked for the federal government for 16 and a half years. So I knew the range program and Forest Service pretty much inside and out. My bachelor's degree was from BYU. That's a Utah school here. My master's was at Colorado State. My PhD at New Mexico State University. Right now I do consulting for the Land and Water USA Foundation, Law USA. I'm the director of natural resource law and policy research for them. I'm also an adjunct professor for Texas A&M University, and some people say, how do you do that if you live in Colorado? Well, my classes are all online courses. I teach ag economics, ag marketing, natural resource economics, and then I try to do consulting on the side. But if any of you heard a good truck driving job or anything, just let me know, because that pays a lot better. But anyway, this research was what I did for my doctoral dissertation. As a matter of fact, when I'm done, I got to put in a plug for myself. It's the only way we can afford to go around and do these kind of presentations is I sell a copy of my dissertation. It costs about $11 to get it printed, and I sell it for $20. So that gives us a little bit of money. So there's a few of them up here. When we're done with this presentation, if you say, man, that guy's full of bull, I want to see what his research is, go ahead and look at it. My dissertation has been admitted in federal district court as an expert report, and it's been admitted into the United States Court of Federal Claims. So I've been an expert witness in federal district court, or submitted reports, expert reports in Colorado, Arizona, Nevada, in front of the Interior Board of Land Appeals. I've given expert testimony, and of course the United States Court of Claims, which is the highest property court in the United States. So that's just a little background on myself, my experience, and this research was something I became interested in when I was actually working for the Forest Service. I worked for a guy named Dave Stewart, and he had been in the Forest Service for quite a few years, been involved in a lot of issues, one case down in New Mexico in particular, which resulted in a U.S. Supreme Court decision in a case called U.S. versus New Mexico in 1978. And I highly recommend that you read that case. It's an eye-opener. But I'll get into it as we go along. If I forget to bring it up, somebody remind me later on. As I go through the presentation, you're going to have questions. Please write them down. I will answer all your questions when we're finished. But if you interrupt me during the presentation, then I'll never get done, because my wife says I'm verbose and I'll talk forever. So let's just try to get through the presentation. When I'm done, I will answer any questions that you have. Just jot them down. Try to remember. This isn't something I made up. This isn't something we need to go to the congressman and ask for new legislation to solve. When I worked for the Forest Service, I wanted to know if ranchers had property rights, what are those rights? Where do they come from? What is the law in place right now? And as I went through all these statutes, and I spent 12 years on the research before I published my dissertation, and I think I've got it down pretty much, whoops, back up. Pretty much have it nailed down. Pretty much ironclad. But if you want to challenge it, here's a copy of my dissertation. It's for sale for $20. You can take it and you can try to tear it apart. You're more than welcome to. I invite anybody, if there's any attorneys here, anybody that know any attorneys, anybody that want to check out anything that I tell you here tonight, write down your question. I'll tell you exactly where to go and find it. I'm not trying to sell you something here. I don't have a dog in the fight. We used to have a ranch. One of my neighbors from Arizona, Brent Lunt's here tonight. Our ranch was just right over there next to Duncan, where his family has a ranch over there. Anyway, we sold that ranch a couple years ago, so I don't have a dog in the fight. It doesn't matter one way or another to me, but when I worked for the Forest Service, I wanted to know the answers. Because I had people in the Forest Service. My boss, I was telling you about, Dave Stewart, I was talking to him one day. I had this great idea as a young guy working for the Forest Service, hadn't been only working for him for a few years, and I said, why don't we make ranchers put up a bond, like the miners do? And if something gets screwed up, we just take that money, we'll fix it. We don't have to drag people in court. I thought that was a great idea. He said, well, we can't do that. And I said, why not? He said, well, because they own their allotments. And I said, what do you mean? Because I had been told my whole life, and all the years, not too many, but a few years that I'd been working for the Forest Service and the BLM, that ranchers don't have any rights. They don't own anything. And he's telling me that they own their allotments. And I said, well, what do you mean they own their allotments? He said, well, they own their allotments. I said, how do they, what do you mean, how do they own their allotments? He said, well, under a series of laws Congress passed, late 1800s, early 1900s, Congress granted them these rights. And I said, so then I'm really scratching my head, and I said, well, wait a minute. If they own their allotments, how can we make them do anything? And he says, this is when his eyes lit up. And he says, you get them to sign something, and then you got them. And it was mind-boggling to me. And so I got to thinking around. I said, well, what are these laws? And he says, one of them is the Stock Raising Homestead Act. Well, I'd never even heard of that law. So right then I decided I'm going to find out about this. And I'd been doing some reading of a book called Storm Over Rangelands. It was written by a rancher in Nevada named Wayne Hage. And I got to know him. And we became very good friends over the years. And he inspired me to go and do the research that I did. And I spent about 12 years of research. Went back specifically to get my PhD, to do study on this subject, and then to report on what I found. I had no preconceived notions when I went into this. I just wanted to know the truth. What are the facts? And so as I went through my research, I did not go into the congressional record and then come back and try to infer some right from a particular statute. If it wasn't spelled out, if the language wasn't plain, then I just went over that. Okay, so as I went through here, this is what I found in this research. Now, before you can even begin to talk about property rights, you have to understand where property comes from. Okay, this is a quote from John Locke. And John Locke was one of the philosophers that inspired the Founding Fathers. And him and Adam Smith are the two most quoted individuals in the early days of the United States Congress. When they first started laying down the laws, these were the two guys that were most frequently quoted. Now, John Locke, this is what he said, and I'm going to read it out loud. I know you don't like that, but he says, though the earth and all inferior creatures be common to all men, yet every man has a property in his own person. This nobody has any right to but himself. The labor of his body and the work of his hands, we may say, are properly his. Whatsoever then he removes out of the state that nature hath provided and left it in, he hath mixed his labor with it, and join to it something that is his own, and thereby makes it his property. It being by him removed from the common state nature placed it in, it hath by his labor something annexed to it that excludes the common right of other men. Basically, when this was a wilderness, some pioneers show up. They go out, you cut down some trees, you skin the logs, notch them, stack them up. You've now mixed your labor with the resources that God and nature had placed there. And by mixing your labor with it, a part of yourself, your sweat, your labor, your time has become mixed with that resource, and now you have a right of property in that resource. And that is the basis for all of the federal land laws or public land laws that were ever passed. The homestead laws, the mining laws, the Desert Land Acts, the town site laws, the preemption laws, every single one of them was based on this idea that you go out, you settle on the land, you mark it off, you build a house, you improve it, you live there for a period of years, and then it becomes yours. Okay? You have now created a right of property. And that is the basis of every homestead, every patented parcel of land in Paiute County that came from a patent from the federal government. That is how property was created. A pioneer went out there, mixed his labor with it, and thereby created property. Now, those are not the only laws that Congress passed to recognize property rights. Okay, and the Supreme Court has said that the power, let's see what my next slide is here. Okay, real estate. We're going to talk about, we'll get back to my train of thought there in a minute, but let's go over real estate. Okay, these are different types of property. Okay, it's a geographically defined area of land. It can include improvements. In other words, real estate can be identified. It's got a GPS location. It's got a longitude, latitude. It is identifiable on the face of the earth. That is real estate. On the other hand, real property can be any fractional interest in real estate. Things like water rights, mineral rights, right-of-ways, timber and stone rights, range rights, etc. And that can include improvements also. It all depends. A commercial piece of property that you might have a lease on, you might have an agreement with the owner to build a fast food restaurant. The restaurant is your property. So that improvement, which normally would be a part of the real estate because it's permanently attached to the ground, in some instances, the improvements are a separate interest. So it just all depends on the circumstances. But typically, anything that is permanently attached to the ground is part of the real estate. Otherwise, these interests are what are called real property. And real property is not always real estate. A split estate typically is divided surface and mineral interest. But the Supreme Court has said it can be any fractional or undivided interest, oil and gas rights, hard rock mineral rights. Let's say you own 100 acres of land. There could be a right-of-way for a county road across there. There could be a right-of-way for a power line. There could be a right-of-way for an irrigation ditch. There could be 10 different owners of water rights in that irrigation ditch. Somebody else could own the hard rock mineral rights under that land. Somebody else could own the oil and gas rights under that land. Okay, somebody else could have a conservation easement over that 100 acres. So just in that 100 acres you have, there could be 30, 40 different owners of real property interest. Okay, so keep this concept in mind as we go through these statutes that Congress passed. Personal property, that's movable objects. Cows, pickup trucks, trailer. Those are property as well. But it's a different type of property. It's movable. It can be taken away. Okay, you can take it somewhere else, relocate it. Okay, so range rights were recognized under state and territorial laws and the courts. Range rights are a type of property right. It's a real property interest. First recognized by the Supreme Court in 1885 in a case called Griffith versus Gotti. Okay, if you have a copy of my dissertation, you can find that citation. Look it up. But anyway, it was a California case. It went all the way to the U.S. Supreme Court. Unanimous decision. Range rights, property rights. Okay? Remember, where do property rights come from? They're not invented by an act of Congress. Okay? They develop from local custom, culture, and the rules of the court. Okay? And that derives from state law. And every state in the western United States had range laws all the way back to the beginning. California, as soon as they became a state and had a legislature organized and passed their constitution and were approved by Congress to become a state, they were the first western state. In 1850, one of the first acts of the state legislature was to reenact as state law the previous Mexican range laws, which came from the Mesa Ordenanzas. Okay, so there were people living in California long before California became part of the United States. People living in New Mexico, Colorado, Arizona. All those states had settlements there that had been there, in some instances, for 300 years. So long before the United States was ever even a country, there were people living in the western United States. They had a custom and a culture and a set of rules, property rights. Okay, water rights. Again, recognized. We'll talk specifically about prior appropriation water rights a little bit farther on here. But I just want to identify some of these different split estate property rights. Right-of-ways. They were recognized under state and territorial laws and customs and the court decisions. This whole body is where property law came from in the various states and territories. And they derived from these prior Mexican laws that had to do with acequias, which are ditches. And you'll see, I'll mention some specific federal acts of Congress that were enacted to actually validate. And what the Supreme Court said that those acts did, they didn't just validate, but they put it was Congress's full adoption, not only of past rights, but to reach into the future so that these rights, that is how these kinds of property rights would be established. And I'll explain a little bit later when we get farther down here, but right now I'm just trying to get you thinking of what are these different split estate property rights. Okay, timber use rights. Under the Mexican custom and law Mexican custom and law recognized a right to use stone, timber, and related products for construction, firewood, and other uses. Did you guys know that Congress actually passed a law specifically saying you have a right to take stone and timber from forest reserves for construction, and it has a list for houses, firewood, mining. It has a whole list of things, and stone as well, stone and timber. Did you know that law exists? I didn't until I started doing this research. There is a legal basis for everything that we have come as Western people to view as our rights. There are laws that Congress has passed to grant those rights. Now I'm going to back up just a second, back to the beginning. When the Constitution was written, they put in there what's called the property clause. And of course, having worked for the federal government, I know these agencies, one of the first things they do is they say, well, under the property clause of the Constitution, we have power to do whatever we want. Well, that is not true entirely. What the property clause says is that Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory and other property belonging to the United States. What they had to deal with was when the original 13 states were formed, there was a huge amount of territory to the west of the Appalachian Mountains to the Mississippi River Valley, that was claimed by some of the new states. Virginia had huge claims. They claimed that their territory reached all the way to the Pacific Ocean. Well, before the smaller states, the landlocked ones, would sign on, like Delaware, Rhode Island, New Jersey, they wanted these other states to give up their claims so that all of the territory would be held collectively by all of the states, with the idea that land would be sold to new settlers and to form new states out of that territory. And so when it says Congress has the power to dispose of, the Supreme Court has said that power is plenary. It's solely and completely in Congress. 3 branches of government: legislative, executive, judicial. Well, Congress has the power to dispose of and make all needful rules and regulations. Now, today, there are some people that say that, oh, well, this is all public land. Well, as we get into this, you'll see that that is a myth. There are no public lands, not in the sense that we think of them, the average person. Terms of law have defined meanings. And this is where all the lawyers in the room, or anybody else that wants to, can go to your county law library or go on to Westlaw and look up the term public lands. It has a very distinctive, very clear definition, defined in at least 16 Supreme Court decisions. Public lands are lands that are open to entry and settlement, upon which there are no prior rights or claims. Now I ask you, can you go out and homestead or make any kind of entry on the National Forest or the BLM? Okay, there is one kind, and I'll get into that later. But the fact is, they're not public lands. They're no longer open to entry and settlement. At the very minimum, they are reservations. They have been reserved and withdrawn from the public domain. Okay, they are grazing districts, and they are forest reserves. Okay, but they are not public lands. They don't meet the definition of public lands, and that is something that is used against the rancher frequently, and I've witnessed it. So, this property clause says Congress has this power to dispose of and make all needful rules and regulations. And so the real question is, have they disposed of them? Because here's the thing, well, you'll wait, don't answer so quick. Don't answer so quick. Because the Supreme Court has said that whenever any right attaches to the public land, it ceases to be public land. The concept is, and the Supreme Court has said this many, 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 many times, once somebody has settled on a piece of land, legally established possession, that land is taken out of the category of public lands. In other words, if you're the first homesteader here and you come and you stake it out, you haven't received the patent yet. The legal title still belongs to the federal government, but you're in possession of that land. You have made an actual settlement. You're a bona fide settler. Now, if somebody else comes along and tries to now claim part of that same parcel of land that you have already settled on, they can't do it. Your possession takes it out of that category of public lands. Nobody else can settle there. Even if Congress, the Supreme Court has said, even if Congress wanted to grant that land to a railroad company, for example, as they did with many of these checkerboard land grants, that parcel of land is taken out of the category of public lands if it has already been opened to entry and settlement. And after 1880, Congress passed an act in 1880 which opened all of the land in the West to entry and settlement. In the original settlement of the United States, you could not enter onto public lands until it had been surveyed and officially opened for settlement. But after 18, and there was many times between 1841 and 1880. 1841 is when the preemption law was passed, and 1880 when there were areas where people had settled, and Congress passed numerous what they call corrective statutes, which said, which were titled or styled an act for the relief of settlers in Oregon, in Colorado, or on some certain place. And so there were many of those, which the purpose of which was people had gone out and settled. It hadn't officially been opened, but Congress said, we're going to approve that. And in 1877, the Supreme Court said it's settled history that Congress had encouraged settlement long ahead of any survey of the public lands, and therefore, we feel that, anyone coming into court with any of these kind of claims has a legitimate claim. And then in 1880, Congress made it official, and everything that had not been settled on at that point was then open to entry and settlement. So whether it had been surveyed, whether it had been officially open to entry and settlement, everything was at that point. Congress encouraged the establishment of ranches throughout the West by passing laws to grant and confirm specific property rights to settlers while reserving other interests to the government. Okay? So what are public lands? Where did they come from? In the early days of the United States, there were vast amounts of lands west of the Appalachian Mountains claimed by some of the states and territories. We covered this. There it is, the property clause. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory and other property belonging to the United States. Okay? So Congress, the Supreme Court said, can dispose of land any way they want. There was one case where Congress actually made a huge grant of land to an individual in southern Colorado because the Court of Private Land Claims had ruled that his claim of a Mexican land grant was valid, but it overlapped another area that the Court of Private Land Claims had already approved of and had granted. So Congress passed a special law for this guy so that he could locate his land anywhere he wanted to where it wasn't already occupied by somebody. So he went out, he located it, sent in a map, it was approved, it was his. Somebody else came along later, started a mining claim on his land. So he writes to the Secretary of Interior and says, hey, I want a patent for this land. And the Secretary of Interior said, I can't give you a patent. There is nothing in the law where Congress has authorized me to issue a patent. And the power to dispose of land is entirely in Congress. The executive has no authority to dispose of land unless Congress grants it to us. So I can't give you a patent. This guy went all the way to the Supreme Court, and the Supreme Court said, it's your land. You can take whatever measure you need to kick this guy off. Because Congress has passed this law, and the law itself is the evidence of the grant. So people have this mistaken idea that unless you have something in writing from a bureaucrat in the Interior Department, you don't own anything. People have this idea that, well, the only land, property rights in the West is these homesteads that have a piece of paper. But Congress has passed many, many grants, land grant type laws that granted everything from easements, right-of-ways, water rights, range rights, timber, stone and timber use rights. All of these rights have been granted by acts of Congress. And the Supreme Court has said that this is what's called a grant in presente. It's an immediate grant. Whatever is in the statute that says you have to do is what you have to do. Under the Homestead Law of 1862, you had to go on to, it's spelled out in the law, go on to the land, you had to mark the corners, you had to live there for 5 years, you had to cultivate the land, you had to file an affidavit with the land department, you had to get it surveyed, and after 5 years, and you had to go back, and there was a whole list of exactly what you had to do to prove up on that land. And in some other statutes, Congress just simply said, the right-of-way for highways over public lands not reserved for other purposes is hereby granted. And the courts have said that was an immediate grant. It did not require that you ask permission. It did not require you get a piece of paper. It said if you need it, it's yours. So the very existence of it is the evidence of the grant. Does that make sense? Congress has the sole power. If they pass a law saying that's all you need to do, that's all you need to do. So for the next 150 years, Congress enacted hundreds of statutes for the purpose of disposing of these public lands to the actual occupants and settlers. The term public lands is clearly defined by the Supreme Court to mean lands open to entry and settlement upon which there are no rights or claims. The legal people in the room, go to Words and Phrases, go to Corpus Juris Secundum, American Jurisprudence, Black's Law Dictionary, any source you want. Go look it up. That is what public lands are. No matter how we might want or wish to make it something else, it's not going to happen. That is the definition, the legal definition. That's what it's been for 100 and however many years. Okay? It hasn't changed. That's what's public land. If it's not public land, it's not open entry and settlement. Now, why is that important? Okay, I'll tell you why it's important. It's important because the very moment public land becomes private property, the jurisdiction, the general grant of jurisdiction to the United States ceases. And the jurisdiction of the state and its political subdivisions, county, takes effect. And as a matter of fact, it even specifically says in the Forest Service Organic Act that the creation of a forest reserve does not affect the jurisdiction of the state or the rights of the citizens or their obligations thereunder. So Congress made it absolutely clear when they passed the Organic Administration Act and started creating forest reserves that there was no intent to keep federal jurisdiction over those lands. And even if they hadn't passed that, the very moment a right-of-way was established, a homestead, a mining claim, any type of private property rights, in a case called Barden versus Northern Pacific Railroad Company, the Supreme Court said it is settled law that the moment any right attaches to the public lands, it ceases to be public lands of the United States. This is what they call black letter law. The case law on this is so numerous that all you got to do is go look up the term. Don't take my word for it. I want you to go look it up, because when you see it, then you'll be convinced. And then you'll know that they've been pulling the wool over your eyes for the last 40 years. It is well settled that all land, I just said that, to which rights others has attached does not fall within the designation of public lands. Where the United States grants a right-of-way by statute to a company which files a map of definite location and the road is constructed, the land forming the right-of-way is taken out of the category of public land subject to preemption and sale, and the land department is without authority to convey rights therein. There's a couple of citations there for you. That Atherton versus Fowler case is very interesting. That was an 1877 case. There's a guy that was claiming a large amount of land in California and under a Mexican land grant. But it was later determined that the land grant was invalid. There were a lot of people who were submitting false claims of land grants at that period of time. And they set up a special court. And when they finally ruled that land grant was invalid, a bunch of people started moving on to this guy's land and setting up cabins overnight, literally. People would move on And overnight they'd have a cabinet erected trying to stake a claim, because now officially it was public land, right? They thought. And the Supreme Court said no. Said even though this is only a possession, a right of possession, that it is not public land. Because as long as he is in possession of it, nobody else can dispossess him. He is an actual bona fide settler on the land. And even if his claim far exceeds thousands of acres, far exceeds what is allowed under the homestead law, it is still not public land. And nobody else can go on there and settle and dispossess him of land that he has settled on and improved. And in this case, his improvement was just an improvement of the forage. Okay, that'll come into you'll see how this comes in your mind later on when we start talking about range improvements. Okay? The two biggest misunderstandings about split estate ranch valuation has been that the ranch property value derives from a permit, or that the ranch has a leasehold value. You own your allotment. The term grazing allotment itself first appears in the law in 1887 in the General Allotment Act. Okay, so the term grazing allotment, that is what you own. It is an additional entry in addition to a homestead. And it was granted in the western part of the United States in areas where 160 acres or 320 or 640 was not sufficient for, quote unquote, the support of a family. Because that was the intent of the homestead laws, was to grant an amount of land sufficient for the support of a family. Not to grant some specific amount of land, but to grant an amount of land sufficient for the support of a family. So, when allotments were made, they were made to the persons who had already improved the land and settled on the land. And what this was based on was the individual state range laws. And every western state had their own flavor, but essentially all the same as water rights. Okay, because up until 1866, there were some people that argued that, well, you could appropriate water, but it's not good against the United States. Okay, well, in 1866, by the act of August 26, 1866, Congress severed all the water in the West from the public lands and made it open to appropriation. Okay, what we call water rights. You guys are familiar with that? Somebody nod. Brent, you know what I'm talking about, right? Water rights. That's where water rights come from. They were the custom and culture under Mexican law. They were reenacted into state and territorial statutes. And in 1866, the U.S. Supreme Court said, the actual name of the act is an act granting the right-of-way to ditch and canal owners over the public lands and for other purposes. That's the actual name of the act of July 26, 1866. But that act is probably the single most important law ever passed by Congress in respect to the western states. Because it did two things. Section 8 of that act was a general grant of right-of-ways. And what it says is the right-of-way for the construction of highways over the public lands, not reserved for other purposes, is hereby granted. Now, somebody will say, forest reserves. When they were reserved, then that's no longer public land. But in the Forest Service Organic Act, it specifically says that nothing in this act shall prohibit the ingress and egress of actual settlers going to and from their homes or property, nor from constructing wagon roads and other improvements necessary to utilize their property. So, even though it was a reservation, Congress said it's still open for establishment of improvements and right-of-ways. And they actually passed another act in 1899 specifically opening or stating that there are specific right-of-ways that could be granted. So remember, a right-of-way is an easement. It's a real property interest. Okay, a permit is not a property right. It's merely an inceptive license required before a property right can be appropriated, constructed, or developed. What is this, Sevier River? What's this river? Okay, let's suppose for a moment that there is some unappropriated water available to appropriate out of the Sevier River. I doubt it. But we'll just say, okay, you could go to the state engineer's office and you could get a permit to appropriate. Okay? Under that permit, you could then go and you could construct a diversion, divert the water, put it to beneficial use, and thereby mix your labor with it, and thereby acquire a right of property. Is the permit a property right? No, it is not. It's merely an inceptive license. Let's say you want to build, I don't know what the zoning requirements are here, but let's say in Junction you own a house. And it's been there 100 years. There were no zoning and that kind of regulation 100 years ago. But now you want to build an addition. Okay, you got to go down and get a building permit. Now it's being regulated. So now you got to get a building permit. So you go down and get the building permit. Is your house worth more now? No, it's still the same house. Until you actually build the addition, mix your labor with the materials and create more additional value, then there is no more additional value. There's no property right by the mere existence of the permit, unless it's a transferable permit, and most permits aren't. Okay, that's a one rare exception. Down in Texas, I know they have permits for building dairies. Okay, and you go through all this rigmarole and you get your permit, then you decide to sell the land to somebody else who wants to build a dairy, and they allow you to transfer. Now it has some value because it allows you to do something that otherwise would take you a long time to do. But these permits, and the Forest Service and BLM have told you for years, they're non-transferable. Well, they're not, but they're not property either. The grazing allotment is the property. It's an actual area of land upon which you have forage and grazing rights. And I'll tell you the actual statutes as we go through this. But a permit is not property. So get that out of your head. I had people tell me that, well, I bought this permit back in... No, you did not buy a permit. You cannot buy a permit. A permit is not property. You can buy the allotment. You can buy the whole ranch. I've seen them sold separately. The base property, what they call base property, is the homestead. I've seen that sold and the allotment sold separate. I've seen allotments divided and part of them sold off. And the government has never opposed a sale. Why? Because what you're selling belongs to you. You're not selling anything that belongs to the federal government. If they have an underlying legal title to the land, then you're not selling that. And as a matter of fact, in the Taylor Grazing Act, it says nothing that the issuance of a permit shall not be construed as granting any right, title, or interest in or to the land. That's all it's saying. Just because they give you a permit doesn't mean you own the land. Okay? If you own 100 acres, somebody else owns, I have an easement over it. Can I sell my easement to somebody else? Yeah. Can you sell your 100 acres to somebody else? Yeah, but they take it burdened with my easement. See what a split estate is? Congress, and we look at a map and we see it's all green or it's all brown. Oh, well, everything must belong to the government. That is false. Absolutely false. There are hundreds, thousands, maybe millions of miles of various right-of-ways. Every state highway that crosses BLM, or Forest Service land, has its origin in this act of July 26, 1866, known as RS 2477. In reality, it's Section 9 of the Act of July 26, 1866. Or excuse me, Section 8 of the Act of July 26, 1866. And the courts have said these right-of-ways, and the whole purpose for that in the first place was because of the Homestead Act of 1862. Some guy had homestead 160 acres. Pretty soon, people would be all homesteaded around him. He's landlocked. Well, we have to pass a law. So they pass a law saying if you need a right-of-way, it's yours. That way you're not going to be landlocked in. Or somebody with a mining claim. Or anything else. And so whoever then homesteaded next to you would take that land burdened with that prior existing right-of-way. Okay, and in forest reserves, the Organic Act, again, contains a section that specifically says forest reserves are open to appropriation of water under federal or state law. So even after...
Sir, don't confuse the water rights with the RS-247.
No, please don't interrupt, okay? You can ask questions at the end. And I will let you go, and you can buy a copy of my dissertation, and you can look it up. Because there isn't anything I'm telling you here that I don't want you to look up. I want you to. And RS-2477 was a general grant of right-of-ways. And I've got a whole list of court cases in there, Supreme Court cases you can go and look up yourself. Let me ask you a question, because the courts always interpret...
I've litigated.
The courts always interpret...
4 years.
The courts always interpret the law in the light of what was the definition at the time. Let me ask you, in 1866, were there any paved roads in the United States? Maybe in Philadelphia, downtown. What we think of as a highway, in 1866, the definition, legal definition, go to Bovier's dictionary. For 1866, is a place for driving cattle. Everywhere people went, they used livestock. The only way you got livestock to market was to drive them. That act was specifically for livestock use. And as time went on, the court said it applied to state highways, to county roads, and there's cases here in Utah where the courts have ruled that the what's called RS-2477, about 1873, Congress decided they were going to compile all the laws in the categories that were called revised statutes. And so they took all the laws dealing with right-of-ways, put them under one section, all laws dealing with water rights, another section, and so on and so forth. That's where RS-2477 comes from. It's just the designation of where they took Section 8 of the Act of July 26, 1866, and that's where they put it. Revised Statutes, Section 2477. Okay? That's all that means. It's the exact same law. The case law is clear. I've got a whole list of them there. You can look it up. Okay? I'm not telling you to take my word for it. You can go look it up yourself. That's why I give it to you. I don't try to obfuscate you and try to tell you, well, this said that or that's. Go look it up. Okay, so right-of-ways, there's over 300 right-of-way laws that Congress has passed. You can go through the statutes at large, and every single session, there's dozens of right-of-ways that Congress granted for all kinds of different uses. Once a property interest is developed, appropriated, allotted, or constructed, it becomes a vested property right. Okay? Once you build the addition onto your house, now you have a property right. Once you appropriate the water, put it to beneficial use, now you have a property right. The permit is an inceptive license. That's all it is. Piece of paper. It's not a property right. What you develop is the property right. And when you go out there and you build 20 miles of fence, or your predecessor in interest, or a pipeline, that's a property right. Okay, grazing allotments. Water rights were the basis for grazing allotments as an economic unit. Then the rancher is an owner of real property, not a renter. Okay, people get confused. The fact that ranchers pay grazing fees also contributes to the misconception that Western ranches have a leasehold value. You're not leasing anything. Was there anybody paying a grazing fee before there was a BLM. When was the BLM established? 1949, the Taylor Grazing Service in 1934. They combined the General Land Office and the Taylor Grazing Service in 1949, formed BLM. Before that, there were no grazing fees. Okay? But yet, these ranches were property in every sense, were bought and sold, and passed by inheritance. Okay? So what is the grazing fee? If you go down to the courthouse, you bought a brand new pickup, you go down here to get it registered, you have to pay a fee. It's an administrative fee. Well, now that you're paying a fee to the county because you bought your new pickup and you want to get a license, does that mean they now own your pickup? Just because you pay them a fee? No. If you own property, you pay a fee. A fee is a form of a tax. It's a one-time administrative cost. That's what a fee is. And in 1905, the new chief of the Forest Service sent a letter to the Attorney General and wanted an opinion. Since under the Department of Interior, which had control over national forests before that point, they had charged fees because in the Department of Interior they had examiners, they had surveyors, they had all kinds of federal employees to administer all these different public land laws where people would come in and say, I want to file on my homestead. Okay, now they send a surveyor out. You have to pay a fee for that. Congress had passed all these laws, and so people were paying fees to the government, to these government employees, for these administrative services that they perform. So he wanted to know, can we charge a fee for grazing, administering grazing on national forests? And his opinion was, well, yeah, we charge fees for all these other things, yeah. That's all it was based on. That was the original basis. If you go to United States Code, look in the notes, and that's exactly what it says. Okay, so then in 1908, the states were mad because this land wasn't ever going to be patented, and so they couldn't charge a property tax on it, and so they wanted it privatized completely. And Congress said, all right, what we'll do is we're going to pass this fund. It's called a 25% fund. 25%, all the money taken as fees, goes back to the state and county. Then remember under the Forest Service Organic Act, it says nothing in this act. And when Congress says nothing in this act, it means nothing. It doesn't mean some things. It means nothing. Nothing in this act, including the authority of the Secretary to make rules and regulations. Nothing in this act shall prohibit the ingress and egress of actual settlers going to and from their homes or property, nor from constructing wagon roads and other improvements. So under that authority, ranchers were building fences, putting in pipelines, and building other improvements, and they wanted to keep control of that. So they said, well, let's start. The Department of Agriculture submitted to Congress a proposal for this law called Cooperative Improvement Fund Act. And they had the same kind of funds in Indian reservations. So then they would take money that according to the act is a contribution. It also says you can ask for a refund if they don't use it to build improvements. But they would take that money, put it into a separate fund in the Treasury, is what the act says, and then that money would be used to build range improvements in the state where it came from. So all the ranchers in this area that were paying grazing fees, the money went into the Cooperative Improvement Fund. This year we'd build a fence on Brent's Ranch, and next year we'd build a fence on Stanton's Ranch, and so that's how that worked. So 50% of the grazing fee went into this trust fund administered under Title 10, or of the, I think it was Title 10. Anyway, it's administered as a separate fund in the Treasury. It does not go into the general, what's called the general fund. And it can only be used for building range improvements. 50%, 25%, and 25%, that's 100%. How much is a rent or a lease? Higher math. 0. Why? Because you are an owner, not a renter. So when they pass the Taylor Grazing Act, and you can go to the Taylor Grazing Act and compare the language of these statutes, and it's exactly the same. When they passed the Taylor Grazing Act, the Taylor Grazing Act said exactly the same thing. 50% was an administrative fee, 25% went to the state and county, and 25% went to build range improvements. So that way it was different. And in 1976, and you don't go to FLPMA, Federal Land Policy Management Act, they combined the Range Improvement Fund from the Taylor Grazing Act and the Cooperative Improvement Fund for the National Forest into one fund. So 25% pays for administrative costs, 25% goes to state and county of origin, 50% goes into range improvements. So when they come to you and they say, we're going to work together, you provide the labor, we'll provide the materials, and we'll build this fence. Who's paying for the fence? You are. Because 100% of that money has to be spent for improvements. They can't use it for buying pickup trucks or having a steak fry or something. Okay? It is what the law says. So, we've answered those two questions. Permit is not a property right, but it doesn't matter because that's not what you own. What you own is called a grazing allotment. Okay? And you are not paying a lease. And they've been telling you this for years, and I have to agree. You're not leasing anything, and a permit is not a property right. They're absolutely correct. But what they fail to tell you, and what they don't know, because 90% of the people who work for these agencies don't know this either. They just do what they're told. I know, I work for them. Somebody above you tells you what to do, and then you do it. That's the way it works. So I'm not saying that there's any malicious thing in mind by these employees. Now, I don't know, maybe some of them. But for the most part, I would say they're just doing what they're told because they don't know any better. And you guys are just going along because you don't know any better. And that's the whole reason why I focus on this aspect. Through this series of statutes, Congress confirmed, sanctioned, and granted split estate property rights to settlers in the region west of the 100th meridian. These statutes granted and confirmed water rights, easements, grazing allotments, and improvement rights, mineral rights, and timber use rights. Okay, the nature of the land in the west was so physically different than the east, Congress established two separate land settlement patterns to accommodate the conditions that existed in the west. You can find most of these statutes under 43 U.S.C. Chapter 7, Homesteads, 15, Appropriation of Waters, 22, Right-of-Ways and Other Easements. Okay, go to the United States Code, go to Cornell Legal Institute on the internet. Type it in, pop up, click on U.S. Code. You can find any law Congress has ever passed, and you can just read it for yourself. I'm going to show you one a little later here that I want you to see. Okay, riparian. They're always talking about riparian. Your riparian area is screwed up. All of you guys. It's your fault. The riparian area. There is no riparian area. It's a myth. Just like there's no public lands. Not anymore. It's a myth. It's mythology. And there is no riparian areas. The riparian doctrine developed in the eastern United States had its origins in English law. The word riparian comes from the Latin word ripa, which means bank, as in a stream bank. Okay, it developed in areas where water was abundant. Okay, back east, Mississippi River, the Ohio, they were used for highways of commerce at a time when fishery consumption and transportation were the dominant uses, and under a legal system that recognized that each owner of land along the watercourse had the equal right to the reasonable use of the water as it flowed through his land. I don't know why I got spaces in here. But that means some guy up in Minnesota has as much say over the Mississippi River as some guy down in New Orleans. Okay, that's the riparian doctrine. If you own land adjacent to the river, every person that owns land on the stream bank has the same right as every other person that owns land along that stream. On the other hand, the appropriation doctrine developed in the western United States and had its origins in Spanish and Mexican law. The first United States Western water law was Kearny's Code, which says the laws heretofore in force concerning water courses, stock marks and brands, horses, enclosures, commons, and arbitration shall continue in force. The Supreme Court has said Kearny's Code was as valid as any act of Congress. And until it was repealed or overridden, and it's never been repealed, but until it was overridden by later acts of Congress, it remained in force. It's still the law in New Mexico today. So that law continued in force. The Supreme Court, in several cases, and it's in my dissertation there, you can look it up, argue with that, argue with the Supreme Court. But the prior appropriation water doctrine is the code of the West, as they say. And now, don't just take my word. There's a case I want you to read. If you're taking notes right now, write down U.S. v. New Mexico. 1978. This isn't ancient law. In 1976, the Forest Service in New Mexico was filing claims for reserve water rights on every drop of water in the Gila National Forest. For everything imaginable, wildlife, fisheries, recreation, even the stock water rights. For everything possible, they were claiming that they owned water rights. I went to the New Mexico Supreme Court and they rejected it completely and said, you're crazy. Forest reserves were established for two purposes and two purposes only. To enhance water yield in order to make that water available for appropriation by private citizens. And if they accepted the argument that the government had these reserve water rights, it would actually defeat the very purpose for which the forest reserves were established for in the first place. And the second purpose was to provide a continuous supply of timber to meet the needs and necessities of the settlers of the arid West. And the U.S. Supreme Court agreed with the New Mexico Supreme Court and rejected all the claims of the Forest Service for claims for water rights for all of these myriad of purposes. And that case, the Supreme Court spells it out. Rehnquist wrote the opinion for the majority. And on the issue of who owned the water rights, it was unanimous. Because you read the dissent's opinion, and they even agree with the majority that the individual stock waterer owns the water rights. So on that issue, they were unanimous. So who owns the stock water rights in a national forest? If nothing else, the ranchers, you guys, own the stock water rights. Okay? The prior appropriation doctrine developed in areas where water was scarce, at a time when agricultural, irrigation, stock watering, and mining were the dominant uses, and under a legal system that recognized the first person to put water to a recognized beneficial use, regardless of whether they owned riparian land, acquired a superior right to local or to later appropriators. You've heard of senior water rights. That's exactly what it's all about. First in time, first in right. That's what the whole appropriation water rights doctrine is all about. Rehnquist explains it in detail in a case right before U.S. versus New Mexico called California versus U.S. That's another good read. Very good, short narrative, succinct explanation of appropriation water rights in the West. Highly recommended. By the Act of July 26, 1866, which I mentioned several times, Congress severed, and this is what Rehnquist said in the California versus U.S. case. Congress severed the water from the public lands, and by the Act August 30, 1890, they established the 100th meridian as the federally recognized boundary of the arid region by reserving rights of way for ditches and canals on all lands patented after that date. He says the same thing in U.S. v. New Mexico. Okay, so what is that area? If you're familiar with the land laws at all, they are what are called the desert land laws. And it was the 16 contiguous western states. And it's listed here, Alaska, Arizona, California. Well, I included Alaska because it's included in there. But in most of the laws, Alaska is not included in there. The rest of them are specifically mentioned in there and included in there. These are desert land laws. This is a 1970 or 1879 map, a report to Congress. And these little black dash lines up there are what are called isohets. They're a measure of precipitation. And even Congress knew in 1890 that you could not cultivate and grow crops on any reliable basis with less than 30 inches of rainfall. And that's why they adopted the desert land laws and the Desert Land Homestead Act, 1877. Rehnquist said that by the Act of 1866, 1870, and 1877, the Congress severed all the water in the West from the public domain and made it available for appropriation under the prior appropriation doctrine of the various state laws. And the Act of 1866, Section 9, says that Congress, I can't remember the exact language, but what the Supreme Court has said is it put congressional stamp of approval on the prior appropriation water doctrine. Okay, now here's just a list. We'd be here all night if I told you every single specific thing about every one of these laws. But I go into detail in my dissertation. So if you want that much detail, you're welcome to look it up and look at all these different laws. I'm going to come back. I'm going to just give you the key statutes, the main statutes, and what they did. The Act of 1866 and 1870 granted agricultural and stock water rights under Section 9 and associated livestock rights of way under Section 8. The General Allotment Act, 1887, is amended, authorized the granting of grazing allotments in 1910. It was specifically applied to forest reserves, and that's when the Forest Service started making grazing allotments in the national forest. Because if you go into the congressional record, that year, 1910, Congress spent the whole summer listening to complaints from people in the West. They had a special investigation of the Department of Interior, Department of Agriculture, and the Forest Service because the people out West were so mad. And so Congress actually enacted a statute which ordered and required the Secretary of Interior to dispose of all land within the forest reserves under the public land laws. Okay, so what does that mean? It means when Congress says that he must do this, then we must assume that he did. Okay, so you can't say, well, maybe Congress did. There's no patent. Guess what? These laws were grants, statutory grants. Of course, there's no patent. The Supreme Court has said the map is the document that evidences the classification and the carrying out of the act. And in my dissertation, I put the whole list of the Supreme Court cases that deal with that. Under the 1891 Forest Reserve Homestead Act, because that's what it is. Go back and read it. The whole thing is a homestead law. But that's what they created forest reserves from. It's that Act of 1891, and it requires that settlers submit a map of their water systems. And you're going to see here in a second how this all ties together. The Livestock Reservoir Site Act in 1897 actually granted 160-acre easement around every stockwater location. So if you've got a ranch and your range has 100 stockwater locations on it, that's 16,000 acres of easement right there, just from that one act. It was a statutory grant, again. And the only requirement was that you submit a map of your reservoir site to the Department of Interior. Okay, that was the only requirement. And in 1919, the Land Department, Interior Department of Interior, issued regulations saying that from now on you do not have to submit a map. It's our job to do surveys, and we'll do it. The Stock Raising Homestead Act of 1916 and amendments made in 1929 and 1949 further reserved and granted range, forage, and grazing rights. This was a specific and explicit recognition of range rights under Section 10 of that act. Improvement rights, and it also said that any mining company that goes on to these lands, these ranges, and destroys the forage, the value of the land for grazing, or the improvements, has to pay the rancher for that damage. And that's why whenever a mining company or oil and gas company goes out, they have to put up a bond with the Secretary of Interior, because under that act there's 3 specific things they can do. Those mining companies can either get your permission, they can make an agreement with you to pay for any damage, or they can put up a bond with the Secretary of Interior. Well, they always do the third, because that's what the bureaucrats are going to tell them they have to do or they need to do. Taylor Grazing Act of 1934 repeated the same language as in these previous acts dealing with forest reserves. And it also has explicit in there. Read Section 1. It talks about land upon which you have grazing rights, upon which the person applying for the allotment has grazing rights. Okay, this language is specific in there. And it specifically references the Stock Raising Homestead Act as authority. And there's also provisions in there that says the acquisition of right-of-ways under all prior existing laws shall remain in force. So just because they established grazing districts did not mean that all these other laws were no longer in force and effect. All of these laws were in full force and effect until October 23rd, 1976. Okay, and what happened on October 23rd, 1976? Congress passed the Federal Land Policy Management Act of 1976 and the National Forest Management Act, same day, 1976. I think it might have been the next day, but the same time. And that is when all of these regulations and rules for now we're going to open up to the whole United States for anybody who wants to get involved in this planning process. And all of these permits that they've been issuing all these years must conform to the forest plan or the resource area plan. And you can read through these laws, and that's exactly what it says. That they got this whole drawn out process, and you got to put it in the Federal Register, and it's got to be there for so many days, and you got to do this, you got to do that. They're going to come up with these plans. Except that these acts actually contain savings provisions. And it says, there's one whole chapter, footnote, that's just savings provision. Okay? But they don't tell you about it. And I tell you what, if you go to the United States Code, you're not going to see it. You have to look under the notes. But it's in the actual statute. And the very last sentence of the Federal Land Policy Management Act says, any action by the Secretary under this Act is subject to valid existing rights. And then in the National Forest Management Act, it has this whole section which says permits, plans, and other instruments for the occupancy and use of National Forest System lands shall be revised as soon as practicable to conform with the forest plan. And it goes on, saying this, until you get to the last sentence. And it says, by the way, it says, all present and future permits, contracts, and other instruments for occupancy and use of National Forest System lands shall be subject to valid existing rights. So what does that say? Did it say some? Did it say most? It says all permits, plans, contracts, other instruments shall be subject to valid existing rights. When I was working for the Forest Service, I asked my boss about that one time, and he said, well, that's simple. Ranchers don't have any rights. What? Congress does not enact vain statutes. They do not put unnecessary language in there for no reason. If there were not prior existing rights, they would not say that all permits, contracts, all, not some, not part, not the ones you decide, but all permits, contracts, and other instruments shall be subject to valid existing rights. It means all are subject to valid existing rights. Your rights are not subject to their plan. And that is why my boss said, you get them to sign something. My very first job when I went to work for the Forest Service, my boss, the district ranger, said, take this paper out to this particular rancher and go up there and get him to sign this. So, okay. So I take it up there and I said, hey, the ranger says you got to sign this permit for this ditch that's on the National Forest. And he said, no, I don't. He said, I got an 1866 Act ditch right away. I said, oh, okay. I didn't know. Sorry. So I go back to my boss. He said, you get him to sign it? I said, no. He goes, dang it. He says, he said he's got a 1866 Act right away. He says, I know. We got to get him to sign this. The idea being that by signing this, you're signing away your rights. You are now consenting to their management of your property interests. Okay? Because how is property extinguished? Under the Constitution, under Article 5, the United States Constitution, there's only one way that property is extinguished. Due process and just compensation. It says that private property shall not be taken for public use without due process and just compensation. That's it. And until that happens, property is not extinguished. Okay. Now you guys wake up, stretch, slap your neighbor, whatever. All right. So if you fell asleep up to this point, my wife says a picture says 1,000 words. She tells me to just shut up and show them this, and they'll get it. Okay? So next time you're sitting in the coffee shop with Bubba, and he wants to know, well, what are these property rights you think you guys got out there? This is what you're going to do. You're going to say, okay, in the original settlement of the public lands, and you can't really see this very well, but this is green right here. This illustrates a 160-acre homestead. And it could be anything. It could be a patent mining claim. But this was when the Forest Service first started making allotments, grazing allotments in the Forest Reserve. This was the basis. Okay, you had a 160-acre homestead up there. Now, a rancher would turn cattle out, and in 1890, the Land Department issued regulations saying that stock raising was so closely akin to agriculture that it satisfied the cultivation requirements under the homestead laws. And so there's a lot of homesteads that were never plowed, never cultivated. Why? Because under the regulations of the Land Department, stock raising was sufficient. And so these guys would turn their cattle loose, they'd go out here and they'd water these springs. That's what those little blue spots are. They're springs or little lakes or reservoirs. You got a creek running through there. And the cattle would water there, and under state law, you would have an appropriation of stock water rights. Okay, approved by the Act of 1866. Congress has already put their stamp of approval on that. Okay? Then the guy would put in a ditch, because under the Act of 1866 is actually entitled an act granting the right of way to ditch and canal owners or to public lands. That was the main feature of it. People were out here digging irrigation ditches, putting miles and miles across what today we call BLM land. Okay? So you put in a ditch. Congress actually granted a right-of-way. And right-of-ways have two characteristics, dimension and scope. Dimension is how wide, how high, how deep. 50 feet on either side of the marginal limits, the courts have said, under this act. And all the subsequent ditch acts, such as the Forest Reserve Homestead Act, 1891, define it as 50 feet. So 50 feet on either side of the marginal limits. If you got a 4-foot wide ditch, that's a 104-foot wide right-of-way. Okay? So now you've got at least 3 separate real property interests here. You've got your homestead, your patented land itself. You have water rights. And now you've got easements coming in here. Okay? So you put in pipelines and troughs. And you spread out water. Okay, you drill a well. As Rehnquist said in California v. U.S., he said that the Desert Land Act, 1877, which authorized establishment of wells, severed even the groundwater from the federal land. Okay, so now you've got all of these, at least a 50-foot wide easement around each one of these water rights. And cows don't fly, they walk, and they got to get from one place to the other. The Act of 1866 was a grant of highways, which the definition of a highway in 1866 is a place for driving livestock. Why would Congress put such a thing in the law? Because of the range rights the ranchers had in the West. Somebody could come along, homestead in the bottom of some canyon, and block your access to your water. So you've got more easements, and remember, stock trails are right-of-ways, and they have to have some dimensional limit, right? You got dimension and scope. Those are the two characteristics of a right-of-way. Scope is what can you do. There was a case where a guy built a saloon on his ditch bank, on a ditch right-of-way in a forest reserve, and the court said, no, that is beyond the scope of the easement. If it had been a mill works or some kind of mining reduction works or something to do with mining, because that's what the water right was for, carrying water to a mining camp, the judge said that might have been legitimate. But a saloon serves no purpose other than getting miners drunk. So that was not a legitimate use. It was beyond the scope of the easement. So then, in 1897, Congress made it a little clearer because the Livestock Reservoir Site Act, which is still on the books, granted a 160-acre easement around every stock water location. Okay, and it's found under Chapter 22 of Title 43 United States Code, which is entitled Easements and Other Right-of-Ways. So you've got these. What's the dimensional limit on a cow trail? What's that? 50 feet? 50 inches. What? You know what? When I started doing my research, I thought for sure, there isn't anything on this. I was wrong. The Stock Raising Homestead Act, 1916, defines the dimensional limit of stock trails is anywhere from 1 to 5 miles in width. In the Hage case, up to a mile. And in the Hage case in Nevada, the judge said, well, I'm going to give him a quarter mile wide right away. Okay? So let's just say you superimpose a quarter mile wide easement over every stock trail. Now, you also got to remember, the Stock Raising Homestead Act was an explicit recognition of range rights. Well, in 1907, the Supreme Court said that the Idaho state range law that gave a diameter of 2 miles radius around every stock water location and that was in 1918 when that one was. 1907 was homestead, so around the homestead, 2-mile radius. Then they had the same law for water rights, but it didn't go to the Supreme Court till 1918. But they said the same thing holds true. So you draw a 2-mile wide radius around every stock water location, okay, around every patented parcel of land. What you have is a series of overlapping easements, okay? And so when the Forest Service, and this was the condition that existed in 1910 when the Forest Service started making allotments, grazing allotments, in national forests. And the specific language of the Forest Reserve Allotment Act says that the allotment would be made for the land covered by their improvements. Okay, so what's a trail? An improvement. In the Atherton versus Fowler case, they said just improving the vegetation itself was an improvement. Okay, under federal law, if you go look at the Federal Land Policy Management Act, there's an actual definition of range improvements and a list, and a rotational grazing system is a range improvement. Okay, so, fences. Remember, the Forest Reserve Act said, nothing shall prohibit the ingress or egress or the construction of wagon roads and other improvements necessary to utilize their property within the reserves. Is range right property? Absolutely. Were they prohibited from building fences? No, they weren't. As a matter of fact, they encouraged it by passage of the Cooperative Improvement Fund Act in 1914. Remember me mentioning that one? So they started enclosing all their allotments, building fences, corrals, okay, plus the forage, specifically mentioned, not just mentioned, but specifically says in Section 9 of the Stock Raising Homestead Act that you're entitled to compensation for improvements, forage, and then there's a whole list. You can read the exact language if you read my dissertation. So I got it in there. Or go look it up. I'll tell you where to go look it up on the internet. Go to Cornell Law. Go to Title 43, and then I believe it's Chapter 7, Homesteads. Click on that, and then it tells you there's a list. Go down to where, I think the very last one, I think it says Stock Raising Homesteads. Click on that, it opens it up. And then what it says repealed. Repealed, repealed. Go to the last one, it says repealed. Click on it, that's Section 10. And it will actually, what you do is you go to it, and it has the statutes at large. It'll say something like 90 Stat 247 or something, but the STAT, that's short for statutes at large. Go to that note, and it's got a hyperlink. Click on it, and it opens up the statutes at large. Takes you right to the page. Right to the United States statutes at large. You open it up, takes you right to that law, and you can read it for yourself. Now, people are going to say, well, Angus, that law is repealed. Yeah, it's repealed. But what did FLPMA say? Because that's what repealed the Federal Land Policy Management Act. Nothing in this act shall affect any prior existing right-of-way, land, or land use right in existence on the date of this act. There's a whole section. Okay, so what are the property rights that you own? And this is what I submitted to the Court of Claims, and they agreed 100%. Okay, water rights, easements and right-of-ways, forage and grazing allotments, improvements, and patented parcels. And those 5 different property interests together is what gives your ranch value. Now, it's not quite as good as just owning it outright. If you were in Kansas, you could subdivide your ranch and put in a mall or whatever. All you get with the grazing allotment is just the forage and the range improvement rights, the right to improve the range. Okay, but it's still a property right and a valuable property right. Okay, you may have been sitting there thinking this whole time, well, gee, I'm going to own everything from the center of the earth to the heavens above. I'm sorry, that's what Congress granted. Okay, and most people will probably be happy with that, because before you came in this meeting tonight, you probably thought, well, Beyond says I don't own anything. I got no rights. Okay? So, these are the property interests. And in the Hage versus U.S. case, the Chief Judge of the United States Court of Federal Claims agreed. These are property rights, entitled compensation, awarded $14 million of compensation. And then the government appealed to the Circuit Court of Appeals for the Federal Circuit, and they reversed it, but did not say that the lower court, the Court of Claims, they did not say that these weren't property rights. They didn't even challenge that. They agreed in principle, but they said this case is not ripe, and so therefore we're dismissing it because it's not ripe. And the reason it wasn't ripe was because Hages never abandoned their lot. Even though they took their permit, threatened them, even came in and took some cows one time. But they kept using their lot and asserting their rights until we got to the Court of Claims. But then the Fed Circuit said, oh, it's not right because, why? The Hages are still there. The government hasn't actually taken their ranch. That was what the Fed Circuit said. They didn't talk about how they put them through hell for 20 years, but they said it's not right because they still have their ranch. The government hasn't taken it. That was their reasoning. It wasn't right. So then the Hages went back and asked for clarification on, well, what we had asked for was a temporary taking because they had kept us off our ranch for a period of time. That was what we had amended our original claim for and what the Court of Claims agreed with. And so then the Fed Circuit said, okay, well, we can agree with that. So the government still owes them $14 million. I don't know if they'll ever collect it for a temporary taking, but that's what the Court of Claims said. So if you hear people say, oh, well, that was overturned, you better go and read the case, because they didn't say that they didn't have property rights. They just said, oh, well, it's not right because they're still there. And they are. Okay. Okay, in simple functional form, if you're any appraisers in here, this is what you would use to value the ranch. This is what we submitted to the Court of Claims and what they agreed with. Okay, there are standard approaches. You know what? It's getting late, and unless anybody's really interested in this from an appraisal perspective, how you're going to appraise this, I'll just skip over these next few slides. Okay, but the thing is, they have to appraise property when they take it at highest and best use. Highest and best use is it legally permissible, physically possible, maximally productive, and economically profitable? Those are the standards to determine. In other words, if they take your water rights, as they did, as we claimed in the Hage case, they couldn't just get away with taking them and then paying them agricultural water value. Because the city of Las Vegas, or actually it's the Southern Nevada Water Authority, had just purchased a ranch north of theirs for like $16 million just to get the water rights off. So they have to pay you at what the market rate is for what's called highest and best use. They can be identified and valued. This is U.S. versus New Mexico, 1978. Hage v. U.S., easements and right-of-ways, 1996, Curtin versus Benson. Oh, this was an interesting case. I got to tell you, every single time, and I've witnessed it for the last 25 years, even when I was working for the Forest Service, every time they take a rancher into court, they're going to cite as authority two cases. U.S. versus Grimmaud, and you can look these up, as in my dissertation, U.S. versus Grimmaud, and Light versus U.S. Both 1911 cases, companion cases ruled on and handed down at the same time. Fred Light was a rancher. He had a ranch. He turned his cows loose on the range. And eventually some of them would work their way up the creeks until they got into the White River Forest Reserve. Forest Service came to him and said, if you're going to graze in a reserve, you've got to have a permit. You cannot graze in a reserve without a permit. And he argued, well, we got a fence outlaw in Colorado. You got to fence me out. This open range state. The land should have passed the government to the state when we became a state, so you shouldn't even own it. I mean, all kinds of arguments. Okay? Supreme Court ruled against them. So if you're going to graze in a permit or in the forest, you got to have a permit. Okay? Next case, Pierre Grimmaud, a Basque sheep herder in California. He bought a big band of sheep. Just started herding them across country. Didn't care whose land it was. He didn't own any water rights. He wasn't an actual bona fide settler. He did not own any range rights. Same thing with Fred Light. Okay? And the Forest Service said, if you're going to graze in the Sierra Forest Reserve, you got to have a permit. Supreme Court ruled in both cases unanimous in favor of the government. Okay? So it looks clear, right? They always cite these two cases, always. Never once have I seen them not cite those two cases as authority. The same year, about 7 months later, the same 9 justices. Here another case, Curtin versus Benson. J.P. Curtin was a rancher in California. He had like about 7 or 8 scattered parcels private land, all connected together with cow trails, and he owned 25,000 acres of range rights. Okay, he goes to the Supreme Court, and he says, it's the same thing, only this is a national park. They created a national park around his ranch and said, now if you're going to graze in a national park, you've got to have a permit, a grazing permit. And he said, no, I don't. I have right-of-ways and 25,000 acres range rights. I have property rights. I'm a bona fide settler, and I don't need a permit. And they said, yes, you do. And they even took some of his stock. At that time, the cavalry was in charge of national parks. They weren't a park service. And they went out and rounded up his stock and took him. He went all the way to the U.S. Supreme Court. And now the same 9 justices that ruled unanimously against Pierre Grimmaud and Fred Light now rule unanimously in favor of J.P. Curtin. What was the difference? He claimed that these are not public lands. I have property rights. I have right-of-ways under the Act of July 26, 1866. I have range rights, and I do not need a permit. And for me to have to take a permit based on what they want it to be, without any regard for my property rights, is a taking under the Fifth Amendment of the Constitution. And the Supreme Court agreed, and that's exactly what they said in the case. As a matter of fact, they distinguished Light versus U.S., which had just been decided 7 months earlier. The Solicitor General is quoting Light versus U.S., and the Supreme Court says that doesn't apply. In Fred Light's case, if you read the lawyer's edition, that's what the Solicitor General says. He says the appellant, Fred Light, has no right to challenge the Forest Reserve or the reserve policy because he claims no prior existing rights. And if you do not claim you have prior existing rights, and you are merely grazing on the public lands, by legal definition, you have no rights. Because these judges have to go by what the law is. And the legal definition of public lands is land that's open to entry and settlement, upon which there are no prior rights or claims. So if you think you're grazing on public land, then you have no rights. Okay? But if you own water rights, and you have easements, and you have range rights, recognized by these specific acts of Congress that they have passed, you also, let me tell you this, you also have stone and timber use rights spelled out and still law. You can look it up in the United States Code. Still there. Why? I'll tell you why. Because once Congress is granted a right, it's granted. It's yours now. They can't say, well, we changed our mind, we want it back. Or else they could repeal the Homestead Law of 1862 and come out here and just start taking people's patented land away from them. If that was the case, you cannot pass a law and take back a right that's already been given. Once it's been recognized, it's recognized. It's law, it's there. That's why in FLPMA, I'm gonna show you. Now this may be hard to read. It is. I'm gonna have to do something to blow it up so people can read it. But this is the National Forest Management Act. Okay? And under Section I, let's see if I can find, oh, wait a minute, this is G, let me find it. Well, I have to read it off of my computer screen. But if you want to come up here and look at it, you can. All right? Okay? All right, this one, you're right. This is FLPMA. And at the top it says, effect on existing rights, repeal of existing laws, and severability. It goes through this whole section, does nothing except talk about how nothing in this act shall be construed as modifying, revoking, or changing any provisions of, and then it lists the different acts, and it says, all withdrawals, reservations, classifications, and designations in effect as of the date of the approval of this act shall remain in full force and effect. Okay, and then the very last sentence is the most interesting one. All actions. Does it say some? Most. It says all. Very last sentence says, all actions by the Secretary concerned under this act shall be subject to valid existing rights. Not some, not most, not even a few. All. All actions. Okay, this is the law that repealed most of these laws that we were talking about. Okay, now, there is a section in there somewhere before this. It says that you can voluntarily give up a right-of-way if you want, or a land use right, and accept, a revocable privilege. Okay, but who would knowingly do something like that? Nobody would. And there was a case in Montana a few years ago, federal district court, in which a guy bought a ranch. He had a reservoir on a forest reserve, and he had ditches to carry the water down to his private land to irrigate with. And the Forest Service was going to cancel his permit and tell him, no, you can't use it anymore, and we want to use that water for wildlife. And he said, no, I own that water right. My predecessor in interest built that under the Forest Reserve Homestead Act of 1891 that I mentioned before, and I own the water rights, and I have easements, and I own the reservoir. And they said, no, because along the line, your predecessors in interest signed these permits that are revocable privileges. And so we can now just revoke them. So he went to federal district court, and the judge said, no, the Forest Service cannot just revoke them. It doesn't matter how many people in between the original owner and him has signed these permits. The government cannot take private property without due process and just compensation. And the fact that somebody might have signed one of these permits does not mean that the property rights are now extinguished. The federal government lost. They did not appeal, and the reason they didn't is because they didn't want to have a 10th Circuit Court precedent. Right now it's just in Montana. Okay, and 90% of the ranchers up there are probably just like you guys. You never even heard this stuff before. So here's the reality check. Ask yourself this question. If you're going to go home and pray about it or whatever, ask yourself this question. If you did not have any of these rights in the first place, would you even still be there today? That's the reality check. Because I don't think you would be. I think you'd be gone already. If they had the right to just kick you off. In the Wayne Hage case, Wayne Hage Jr. trespass case, they sued him for trespass. We went in and argued Curtin versus Benson. And as soon as we put that in our argument, we said, Your Honor, this case is not about trespass on the public lands. And we're not challenging the government's ownership of the land. We're saying we have property rights that give us a right to be here, and we are not trespassers. And we cited Curtin versus Benson. And as soon as we did, the United States Attorney filed a motion to dismiss. So we opposed the motion to dismiss because we said, Your Honor, if you dismiss this case, they're just going to come after us again another way. We want an answer. So the government wanted to drop the case. And that is why there's not a lot of case law on this. Because every single rancher that has ever brought up the right issue, they've dropped the case. Or they've gone to the guy and they said, we thought it over and we're not going to give you a 40% cut after all. We'll just give you 25% cut. And the guy is so happy that they're only taking 25% of his property that they agree. So that's why there's not a lot of case on this. I shepherdized the case. Are there attorneys in here? You know what I'm talking about. They have Shepherd's Compendium. If you want to know if a case has ever been cited, you look it up, and it'll tell you the citations of where it's been cited before. You know how many times Curtin versus Benson was in there, was being cited? 2 times since 1911. And both of them had to deal with something other than grazing. They were just general property cases where they were claiming a taking under the Fifth Amendment. Nobody had ever used this. Or let me change that. Anybody who ever had, the case must have been dismissed. They must have dropped it. But in every single trespass case that BLM and Forest Service brings, every single one they cite Light versus U.S. and U.S. versus Vermont. Why? Because those were cases about guys that did not have rights. They had no rights. They didn't even claim they had rights. And that is the difference. So if you walk out here tonight, you are grazing on the public lands. You are sadly misguided. Why do you think they call them grazing allotments? Because they are grazing allotments. And that term, you can look it up also. Write it down. Go look it up. Just like the term public lands has a meaning, a grazing allotment is a property right. Okay? So, I had one more thing I was going to show you. Okay, this one. Maybe it'll come in focus. Maybe my eyesight will get better. But there it is, section I. And this is the National Forest Management Act. Okay? Resource plans and permits, contracts, and other instruments for the use and occupancy National Forest System land shall be consistent with land management plans. These are the plans they spend a year getting ready, and they have all their experts come in, and they put it out for public comment, and they put it in the Federal Register. And then you have to abide by it, because now the forest plan becomes part and parcel of your permit. And you have to agree to it, and you have to sign it, right? Let's see what it says. Those resource plans and permits, contracts, and other such instruments currently in existence shall be revised as soon as practicable to be made consistent with such plans. When land management plans are revised, resource plans and permits, contracts, and other instruments, when necessary, shall be revised as soon as practicable. But any revision, does it say some? Does it say most? Any revision in present or future permits, contracts, and other instruments made pursuant to this section shall be subject. What does shall mean? Is it optional?
No.
Shall be subject to valid existing rights. Their permits, their plans, contracts, and other instruments are subject to valid existing rights. Your rights are not subject to their plan, to their permit, to their contracts or other instruments. Whatever you want to call them, your rights trump their plan. Congress says so. This isn't my interpretation. That's what it says. You can read it for yourself, and then you decide. I think that's my last slide. You guys are, okay, here we go. The definition of insanity. This is the last slide up there. Insanity is doing the same thing over and over. Actually, Einstein said it 5 times. Over and over and over and over and over again, and expecting different results. And we've been doing the same thing over and over and over again for the last 100 years. Or more. It's been over 100 years. Okay? You got to do something different. What you've been doing ain't working. So that's my presentation. Stan, I don't know if what you want to do.